I'm waiting to be realized.
You're alive?
Good morning. We're taking up H6, continuing testimony on H655 and actuating the ceiling next one.
Thank you, Senator Sears, for inviting me to testify on this topic. I do want to, and good morning, committee, Jay Pershing Johnson, Governor's Legal Counsel, for the record. I want to thank this committee that it's done for the work that it's done to date, specifically with respect to S58, the drug modernization pieces, the raising the age provision, and S195 with relation to some bail reform and tools for addressing violations of conditions of release. So I think that it's really important that that you've done this work. I mean, I think that it's, you know, a significant debate and thoughtfulness, and I really appreciate that work.
Thank you.
Sure, no, I mean, you deserve it. This then would be the third prong, I think, of what the governor would see as the governor's public safety package. And for a while now, the governor has favored a shift to universal sealing of criminal records over our current system of expungement. You have the experts in the room who practice in this area, so I would defer to them on a number of technical practice questions, procedural questions. But just to be clear, we support second chances for jobs, housing, education, and opportunities to avoid the negative collateral consequences of a criminal record. But we believe this can be accomplished with a system of universal sealing, which ensures accountability for repeat offenders when necessary. And further, I mean, and this is part of, I think, a general sort of policy theme that we see in the legislature, is each time a new firearms restriction is passed, its fundamental underpinning is the federal background check system. This background check system only has value if background checks have integrity, and the background check system relies on the existence of criminal records. So I would just sort of flag that as one of the many reasons that sealing is probably a superior tool than expungement. So this, in 655, universal sealing system, and universal is a little misleading. This bill does not include sealing for juvenile records or diversion records, but it would make all nonviolent crimes sealable within a relatively short time frame. By moving to universal sealing, we can provide more individuals greater opportunity to pursue better jobs, higher education, obtain loans, or lease an apartment in a more timely manner while maintaining public safety. It also provides a mechanism for automatic sealing, but that is something I think in the House, it was determined that it's a little, you know, too soon to adopt a proposal for that, so that there's going to be a committee looking at that. But I think that there's at least a device for moving forward an automatic sealing regime. So we would prefer a system of truly universal sealing for all the reasons, but this, and again, others can testify to this, but the availability of records cuts both ways. Sealed records would be available when an individual is a defendant in a criminal action, and the sealed records of the defendant are integral to their defense. Or others, actually. Sealed records will be available to entities that are required by state or federal law to request a fingerprint-based background check of criminal history information. Sealed records would be available for background checks for firearm sales or transfers, and they'd be available for civil action concerning law enforcement or prosecution actions and other civil actions. So that's generally my support for this bill. I have a couple of specific edits that I would suggest. So on page 20, 20, sorry. And again, I guess there are two things that I generally would note, or one thing that I generally would note is the House sort of imposed this concept of super sealing after 10 years, which came after the determination that there would be, you could basically petition for sealed records. Under our expungement regime, you at least have to be able to show that there was no intervening conviction. We would actually have preferred to expand that to pending charges or intervening convictions at the time of the petition for sealing and or expungement. But then, so they took that out because the rationale was sealing, if you have records, if you have access to the records for sealing, why would you have to consider these intervening crimes? Because the sealed records can be used for criminal justice purposes. Well, that makes a certain amount of sense until you do a super sealing period at 10 years. So for those records that then become completely unavailable after 10 years, there has been no consideration of intervening crimes. So I guess that was my concern there. But so I would say that on page 20, with respect to new charges, section 7604 in line 10, I would say that this should be, so this actually addresses new charges. If a person has a criminal charge pending at the time of the petition for sealing or expungement is before the court. So I would take out the word, I'd add to the word expungement, sealing or expungement. Because again, this bill allows for certain kinds of expungements, and so expungement is still anticipated in a lot of this language. So I would want consideration of criminal charges pending as well as convictions in the intervening period. It's just, the thing that concerns me is if you reduce the time for sealing to 3 years from the current 5 years, and cases aren't moving, you won't have, theoretically it's possible, you would have cases that never actually have a conviction in 3 years. So I do think that there should be consideration of pending charges. So, and again, the concept being, people who are receiving the benefits of sealing and the benefits of relief from collateral consequences, those individuals have a certain responsibility to then sort of comply with the social contract. You don't get the benefits with none of the corresponding obligations would be my position. So the idea that you could simply petition to have your record sealed, regardless of the criminal record in the intervening period, it seems like an unfair trade for communities and victims in Vermont, to my mind. At that point, you're solely focused on the impact of the criminal record of the person with the criminal record, regardless of their record in the intervening period. I think that's, I think Vermonters expect more from the benefits that we're conferring for people who are seeking those benefits. So that's sort of the underlying philosophy there. On page 25, I would remove, actually, the super sealing period. I would just take out the language in line 1.
That's a new term that I'm still not understanding. Super sealing.
I think this was sort of in the general.
Sorry, maybe I'm just not getting it, but what is the difference between sealing and super sealing?
I think that in the parlance that has been adopted, people are calling the period after the 10 years that's added here in line 1 to be super sealing. Under a sealing regime, there are a number of uses. After the 10-year period, the access to those records is limited to all but for a couple of uses.
Okay.
So that's that.
And we just had a conversation with Tucker Jones about, say, fingerprints and DNA. Is that part of the criminal record, or is that just part of the? So then that's a policy choice for this committee to make.
I believe that's a policy choice for this committee to make. I believe records in the current expungement regime, everything is deleted.
Right, but should it be so? You had DNA 20 years, 30 years later may prove that this person committed the crime, or may actually prove that he did not commit the crime.
Mm-hmm. Well, that's the value.
Should that DNA be sealed or however you would,
Well, I mean,
or the fingerprint or whatever.
for some,
Fingerprints are so old fashioned now that
yeah.
I think it's more DNA.
I think that the issue is not what's available, but the purpose of availability. So all records are available for certain limited purposes. I think that the argument for just a universal period of sealing is, or sealing as a universal matter, provides access to those records for any number of criminal justice purposes.
Well, that's where we're,
Yeah.
where but anyway, thank you for clearing up what a super seal is.
Well, that's my understanding, and that's just hearsay, so, but I believe that's correct. I then get.
Jay, before you go on, is your proposal that we would eliminate so-called super sealing altogether and there would just be sealing regardless?
Yes, I believe this was a change that was made at the very, very last minute in House Judiciary. It was basically, from what I had understood, a fairly complete bill that was going to be voted on a Friday. And between the hours of 9 on a Thursday and 9 in the morning on Friday, this provision had been inserted. So I would say that there was not a whole lot of testimony or anything with respect to this provision, but it was expedient for purposes of obtaining certain votes in the committee. So I think that that's why I was that's not why I would suggest it comes out. I just don't think it received a whole lot of testimony in public.
Mr. Chair, if I might, yeah, and I didn't know the micro history of how the House added it or not, but it seemed to me an attempt to split the difference between what caused this bill to founder last time, which was that when you were talking about the responsibility that people have who receive sealing owe for that benefit, the other way to look at it is that in many cases now they have expungement, where their records are expunged completely. No one has access to them.
Right.
We are moving to a sealing regime, so they're actually losing benefits. And
unless they don't reoffend.
Right.
They're not.
But so one of the ways I had been looking at it last year and the year before is that since we are taking those benefits away, it's our responsibility to make sure that we're not replacing it with a regime that's porous, where lots of different people can go through those records, because under expungement, they had an assurance that no one would be going through the record. And so what this committee tried to do 3 or 4 years back was to say that there would be a sealing regime very much like super sealing, with a judge having to give access to the records. So I don't know that I prefer what the House did, but I at least credit their attempt to keep faith with what the Senate and the House offered as expungement. So in other words, we promised a large group of people, including some people who were coming through the system, that there was a process for them to, you talked about how sealing provides greater access to employment and other benefits, but expungement provides a much better benefit, because here, OPR, for instance, has access, and so your professional opportunities are limited by your existing record, whereas in expungement, they wouldn't be. So anyway, I just wanted to add that as a commentary on super sealing, and that it is one way of trying to square that circle where the bill crashed and burned last time.
I completely appreciate your policy choices. And that, again, as it often is, boils down to a choice between public safety and what we perceive to be the benefits due to the individual who is offended. I would argue that this was not significantly debated in the House committee. It was also my understanding that they had the votes. They simply made this change to change the constitution of the votes that were received on this bill.
Which we can't really get into.
No, I understand that, but it was my understanding that there was a fairly significant bipartisan vote in favor of the bill prior to the change. The other then sort of collateral changes I would suggest would be on page 26. I'm sorry, yes, so that was 25. 26 would be in line 9, again, removing the language in perpetuity and shall not be subject to the tenure limitation. Same for 15 and 16. And then there's some very strange language that starts at the very bottom of page 26 and carries over to the first 3 lines of 27.
I also thought that was strange.
Well, I mean, the idea is that the legislature can only legislate as a body, right? This would be essentially assigning a legislative committee,
Veto power.
yes, veto power over rulemaking. So I would suggest
I think
that.
it goes back to coyotes.
It might.
Yes, well, if you can get this and,
I understand your concern about the language.
okay, great. So
But I
it
meant
sounds,
that if you followed
Yeah.
S-258,
Oh, I followed it.
that, you followed it, Senator, I followed it as well. That's where it all came in, was the argument between the Fish and Wildlife Board,
Yes.
and Elkhart, and I think that's where this is coming from.
absolutely possible.
So it's coyotes.
Yeah, I think a lot of it is going to boil down to coyotes and poop eventually. So I would say that lines 1 through 3 on page 27, lines 11 through 14, starting with access on line 11 on page 27, and same at the top of page 28. So I would just take out that entire sentence, starting with access and ending up with 842C. Tucker may have testified to this, and I apologize for missing his testimony. I had a doctor's appointment. But Tucker and VCIC would be the entities to speak to the language in section 4 on page 28, and that's lines 14 through 20. I just would note that.
I don't, Senator.
Thank you. I just wanted to make sure I'm understanding the weirdness that's happening at the bottom of 26 and onto 27. So
Yeah.
is it essentially if somebody is trying to become a police officer, or if there is a hearing about a police officer's license, the Criminal Justice Council may inspect and receive copies, but they can be prohibited from receiving those copies if LCAR objects to that? Is that?
Well, so no, what the issue is, it adds this language upon adopting rules outlining a process for handling sealed records and maintaining confidentiality and standards, right? So basically you have a rulemaking process now in Title III. That's administrative rulemaking. LCAR is a part of that review process. But once rulemaking is essentially an executive function. Once the rules have been once the rulemaking authority has been given by the legislature and appropriately constrained by the legislature, right? So it's not an unconstitutional delegation of legislative authority. So that's the rulemaking process. That's the administrative process set up in Title III. This provides for rulemaking. And then it goes on to say that the LCAR will have a veto over the rules. If they object, effectively the rules can't go into effect. That's just basically the legislature delegating its legislative authority to a subcommittee of the legislature. It is not constitutional.
Thank you.
Can I just clarify something? So the intent is that they would object within their statutory authority under the APA. They wouldn't be granted some new authority. So if it's within the ability for LCAR to object that it's contrary to legislative intent, or those other things that LCAR is allowed to object under. So if they use their authority to object under what they can do now, then the agency can't continue and move on if there's an objection.
Right. So basically it's an LCAR.
So if I need to add a reference.
It's an LCAR veto. This language, you don't, if that all is the case, right, if that is the intent, you don't need this language. That language is already provided in the LCAR authorizing language. If your intent here is to have LCAR be able to veto rulemaking, that's where the constitutional issue arises.
If that's what you meant.
It's not, the intent is that that the legislature is granting the agency access to the sealed record conditioned on that they go through the process of rulemaking, that it is then, and that LCAR then does not object based on one of its statutorily granted basis for objection, that then the agency can't ignore the objection, fail to correct the rule based on the objection. They can't then move forward.
Right, which amounts to a veto of the rule.
Right. I agree. I take the intention. I know what they were trying to do. It has struck me as hinky from the first time I read it. And if you can do this here, it seems like we would see it in a lot of bills, because it's a pretty backdoor way of creating this kind of.
Generally, the process has been, in my own experiences with judicial rules, not administrative rules, but with judicial rules, if we have concerns as the Judicial Rules Committee, we usually express them to whichever group is presenting them, the, family court or the criminal bar, whatever.
Yeah.
And those are addressed, and we come back to the rules, unless they're emergency rules, which have already been promulgated by the Supreme Court, and then we give our objections there. I don't ever remember a time where we, not had that cooperation with the judiciary.
Right, there is a certain amount of cooperative process that happens with LCAR and other review committees, but at the end of the day, it is permissible for the executive branch in the administrative rulemaking process to file regardless of LCAR objections. And then there is a presumption that if the rules are challenged, that the LCAR objection will be taken into account by the court. The other thing about legislation is the legislature, acting as a body through the bicameral process and presentment, can do any number of things. First of all, it can constrain the rulemaking authority of the entity making the rules. It can also go back to any rule that's been made in the past and modify the rule or eliminate the rule or do whatever it does through the bicameral and presentment process, right? That's the Constitution's structure for legislative authorizations or vetoes or whatever. It can't be delegated to a committee or an agent of the legislature.
Okay.
Okay.
I don't think we're necessarily disagreeing.
Okay. And then the other change that I would just suggest is on page 36 at the very bottom. Again, it sort of relates to this idea of intervening offenses. So in line 21 at the bottom, I think I would insert, so provided the person has no unresolved pending charges and then has not been adjudicated for any subsequent municipal. That's again with respect to municipal offenses. But those are my specific comments.
Thank you.
Good. Sure, thank you.
Thank you.
Appreciate the opportunity.
Before I go, going back to the super sealing concept. What would you suggest?
Oh, I would just suggest taking out the language after records. So in line 1 on page 25, I would say entities may access and use sealed records only in the following circumstances. Okay.
Any other questions for Jay? Jay, thanks so much for joining us.
Thank you so much for having me.
We're going to continue on. Our next witness is Timothy is Marshall Paul, the Deputy Defender General.
Thank you and good morning. Marshall Paul, Deputy Defender General. I want to start by talking about this bill generally before I get into the specific sections, because what this bill does is all but eliminates expungement from Vermont. Expungement is really the gold standard when it comes to record confidentiality. Records are removed and destroyed, not kept and given broad access to large numbers of people. This bill would replace almost all uses of expungement with sealing, which doesn't provide anywhere near the level of confidentiality that expungement does. And we have a long history with expungement in this state. We've had expungement on the books since at least 1971. That I found the oldest Title 13 I could in our office, which was in 1974, which is just interesting to see how small that is compared to today's Title 13. There's sealing, there's expungement provisions in there that date back to 1971. I'm not sure what was there before 1971. So we have a long history with expungement in Vermont. And with our current system of petition-based expungement is actually not that old. It came out of this committee in 2011 at a bipartisan bill sponsored by Senator Sears and then Senator Benning. And this bill would eliminate that petition-based expungement entirely. And since that time, since that bill was passed, thousands and thousands of Vermonters have benefited from the expungement of their records. And I really want to talk about, I think the most important sort of feature of this bill is the difference between expungement and sealing. It's been described that sealing is sort of confidentiality with some access limited to small groups of people. It's actually much broader than that. First of all, records that aren't destroyed will eventually become public. These days, literally every month, there are cyber and hacking attacks on judicial systems, departments of corrections, prosecutorial offices, and public defense offices all the time. In fact, I was just looking back, and just since the beginning of this year, there's been news about cyber attacks on judicial systems in New York, Pennsylvania, and Kansas. The one in Kansas resulted in the loss of data. The state of Kansas could not. This was one of these ransomware attacks, so they took the data and tried to, told the state of Kansas, we're going to release this to the public if you don't give us X number of Bitcoins. The state of Kansas couldn't pay that by law. They can't pay bribes. So the hackers dumped all that data onto the internet. It's now available for anybody to see, including confidential records. That problem is only going to increase. We see that here in Vermont. We see hacking and cyber attacks affecting systems in Vermont, in our public sector, in the private sector, more and more frequently. There was the huge cyber attack that resulted in large loss of data at the University of Vermont Medical Center. There's been cyber attacks on our governmental organizations here in Vermont. So really, if we don't have expungement, if we don't have some way to actually destroy records, and now that records are all being kept electronically, they will get out. Leakage is another problem. One of the many exceptions to the confidentiality of sealed records that's proposed in this bill is to give basically unfettered access to anyone working in a law enforcement agency. I did a little bit of research looking at the state employees list and what I could find publicly about employment statistics in sheriff's offices and local law enforcement. And we're talking about at least hundreds and hundreds and hundreds of people who would have access to those records. And that access is limited to law enforcement purposes. But when you look at the definition of law enforcement purposes, it's actually incredibly broad. It basically describes every function that anyone in a law enforcement agency would do. And so really, you know, the idea that hundreds, possibly more than thousands of people would have access to these records means that at some point, information will leak out. We have, in the juvenile system, we have a similar sort of situation. Records are not expunged, they are kept confidential. And they're even kept more confidential than this bill proposes in the juvenile system. And yet in the juvenile system, every day I hear information that I shouldn't hear. I hear people disclosing records, disclosing information that's supposed to be kept confidential. And so really the fact is, the more people who have access to confidential information, the more of it is going to make it out into the public, the more of it is not going to be kept confidential. Sealed files would also regularly be disclosed in unrelated court cases. If expunged records don't have to be disclosed to the defense, because Rule 16, which is our rule on criminal discovery, and cases like Brady and Giglio all use the same language, which is that prosecutors are required to disclose evidence that's in the possession, custody, or control of the attorney. When a record is expunged, it's not in anybody's possession, custody, or control, so it doesn't have to be disclosed. If they are sealed, then they will have to be disclosed. And frankly, that means that they will become public. They will become part of a court file. That court file does not even belong to the attorney, it belongs to the client. So every criminal defendant, if there are records disclosed of witnesses, of other people involved in the case, people who may be completely unrelated to the case, they just happen to be on the scene. Let's say somebody is driving down the road and witnesses an accident that's charged as gross negligent operation. If they have a criminal record that's sealed, that may have to be disclosed, and then it would be in the defense file, and then that criminal defendant would have access to that record in perpetuity, because the defendant owns their own file. That's one of the principles of professional ethics. So really, you know, that's just another way that somebody who's completely non-offending, not doing anything wrong, can have their records exposed to the public. We also see that predictably, when a bill that allows access to records that used to be expunged, that used to be completely wiped off the books, is introduced, we had organizations coming out of the woodwork asking for access to the records. If you look back at the testimony in the House, you can see that the groups that got access to records in the bill represent only a fraction of the groups that sought access to records. And today there was, you know, DCF was in asking for access. They wanted an exception so that they could see sealed records as well. And, you know, I think that probably every year, if we were to adopt this bill and eliminate expungement and have this sealing with access available to various organizations, every year we're going to have people coming in seeking, saying that they also need access. The Human Rights Commission wanted access. The Bankers Association wanted access. There's a number of groups that wanted access to these sealed records. So I also just want to point out that expungement works. There was a Michigan study that looked at the effects of expungement and found that people whose records were expunged saw a median 25% increase in income over the next 2 years. And, you know, expungement also works in Vermont. You know, famously, our former Attorney General had a fairly serious crime expunged when he was young. And he went on to become successful, productive, and effective. Who knows if he could have accomplished all that if his record was merely sealed and therefore accessible to hundreds, if not thousands, of people in state law enforcement, in other parts of state government, to the Criminal Justice Training Council, and whoever else is granted access. You know, would that youthful offense have stayed confidential as long as it did? We don't know. And would he, but we know that the chances are certainly greater that it wouldn't, because more people would have access. And would he have been able to go on and have the success in public service that he had if that had been revealed much earlier in his career? Again, hard to say, but we do know that it would have reduced his chances. I want to address a couple of specific points in the bill. And those are just a couple things that have come up today. One is the idea that the idea of getting rid of the expungement of records of non-conviction of dismissed cases. Those are, if anything, those should be at the top of the list of records that are available for expungement. I even heard one of the witnesses say that just because a case is dismissed doesn't mean that the person is not guilty. That's just not true. Like, that's the opposite of the law. The law is that you are not guilty until a jury finds you guilty, a judge finds you guilty, or you plead guilty. Up until that point, you are presumed innocent. That's a legal principle that goes back before the Magna Carta to Roman law. So we have a lot of concerns about that. We think that if there's any place that expungement is particularly appropriate, it's for records of non-conviction. And as to the questions about the super sealing provision, our support for this bill is contingent on the super sealing provision. That, from our perspective, and I shouldn't even say our support, because we did not support this bill. We simply said, with the addition of the super sealing provision, we withdraw our objections to the bill, because we don't like the idea of losing expungement. But given the compromises that were made, we looked at the super sealing provision and decided that was a compromise between expungement and sealing. Expungement being, really giving you the best, most practically confidential effect. Sealing being really wide open to any number of people. And that this super sealing idea where the records are maintained, but access to them is very much limited and they're no longer available for just sort of general law enforcement purposes and all of that. We saw that as sort of a compromise, and that was part of the reason why at the last moment we took a bill that we had opposed all the way through and said, you know what, with that provision as a compromise, we're willing to withdraw our opposition reluctantly. So for us, that provision is very important. There's got to be some point, I mean, really, there's been plenty of research on this that's done.
Go ahead.
Sorry to interrupt you, Marshall. Okay. I take the point, and I think you make it very well, about the broadness of access. And so I'm wondering if I'm characterizing your position or the office's position correctly. So super sealing was something that caused you to withdraw your objections, but in order to support the bill, you would want constrained access within 10 years. And I don't want to imagine what would gain your support, but it seems like what you're saying is Defender General's office views the access between the clock running and 10 years as radically too open. And so, I've mentioned it before, but our compromise in here 4 years ago or whatever it was to hear the complaints of those running the system, that expungement was consuming huge numbers of employee hours to actually get rid of the records, and that a single track would be more efficient and more, just easier to maintain for the state. But married to that would be that there would be more like sealing would be super sealing from the beginning, where it would not be open access for law enforcement and other groups, especially not other, unrelated to me agencies like OPR, but that we would have access, but only in very tightly controlled situations. And my memory was that a judge had to open the records to a prosecutor or something like that.
And that's actually, so we did there's a couple of 50-state surveys of sealing and expungement laws out there. We found in looking at them that none of them were actually accurate. And so we did our own 50-state survey of sealing and expungement laws. A lot of that work was done by my law clerk Natalie over there, fantastic. And first of all, if we were to eliminate expungement the way that this bill does, we would be one of very few states that doesn't have expungement. Almost all states have both sealing and expungement. What that means in each state differs, but one of the things that a lot of states have is when a record is sealed, or they use all different terms. Some of them use expunction, there's sealing, there's vacatur, all kinds of different names for them. And in some of the states, what they do is they say law enforcement can have access, but their access is conditioned essentially through a warrant process. They have to go to a judge and say, we believe that if we can access this criminal record, it will assist us in solving the following crime. And the judge can then say, okay, I grant you access the same way that the judge would grant a search warrant. So there are ways that you know, that one-track system could be done that does limit the sort of broad availability of these records and information. And that would make us more likely to support the bill. Absolutely.
So, go back to the purpose of the bill at the beginning. And I'm not necessarily disagreeing with your positions, but the purpose of the bill was to expand crimes that would be eligible for sealing over what we had currently, which was up. From 2011, we continued to add hodgepodge crimes. For example, you know, who knew careless and negligent driving couldn't get expunged, but DUI could, or sealed. DUI, I think, is sealed. But you couldn't expunge it, CNN, even though it was dropped down from DUI. We added crimes like that. So, thought that it would be a good idea to seal. And we also knew the extensive, I believe there are 5 full-time people in the court administrator's office who do nothing but expunge records. So if it was sealed, it would be easier. You raised some good points, and I personally objected to the House bill section on deferred sentences. I think they should remain expungible. I don't think that's fair to that particular system, which is based upon, we'll give you what in effect is a governor's pardon if you do well for a period of time.
And which has been in effect for such a long period of time. I mean,
That's been there for as long as I've been here.
It's been before I was born that they've had deferred sentences getting expunged.
So that's one of the things that we're proposing to change. But if we wanted to expand the crimes in any meaningful way, it seemed like we needed to get cooperation of both the administration, law enforcement groups, as well as your group and all. And so this is a result of compromise, quite frankly.
I understand that, but one of the funny things about this bill is it doesn't actually expand eligibility. If you take a look at the list of crimes that are eligible for expungement right now and compare that to the list of crimes that are available for sealing under this bill, they've added a whole bunch of misdemeanors to the list of unexpungible crimes, and they've added a few felonies to the list of, I said expungible, to the list of sealable crimes. They added a few felonies to the list of sealable offenses, but some of them are felonies that I literally have never seen charged, like, you know, crimes related to mills, dams, and bridges, or the unauthorized removal of human remains, or the great I don't even know what it's called, relating to great markers and ornaments, the felonies that were added are felonies that are not commonly charged. And a lot of the misdemeanors that were added to the list of non-sealable offenses are crimes that are commonly charged. So I don't think this list actually expands eligibility in any significant way.
A good point, because I haven't gone over the crimes. Senator Shane.
So one dilemma I'm facing with the idea of expungement for a dismissed offense is, let's say there's a situation, somebody's unlawfully arrested, there's a search that was done that was clearly unconstitutional. That person's case, it gets dismissed. They don't want to have to deal with the collateral consequences of having been arrested. But they also want to eventually file a lawsuit and for damages because they were unlawfully searched and they had to go just through this whole process. What are your thoughts on that situation? I mean, how can that person get justice for having been unlawfully arrested and then having their case dismissed, but they're also trying to reduce the collateral consequences of having been charged?
I think the easy way to address that would be to do, so most states, as I said, have both sealing and expungement laws on the books. And I think that we should as well, and we do in some places in our statutes, like we do have both sealing and expungement, but making them both available in that situation would, for example, allow somebody to, move right away to seal the records and then not expunge them unless and until they either file a lawsuit or the statute of limitation runs and they can't file a lawsuit. I did want to also address a little bit, and this is the stuff on page 26 and 27. I agree with Governor's Counsel that is totally unconstitutional. But I think more than just removing the language that gives LCAR essentially veto power over a rulemaking process, the idea, I think, this is a little bit of speculation, but I think the idea that the House was trying to implement here was just to ensure that whatever rules were written matched up with legislative intent and giving LCAR the chance to sort of veto if it did not. That I do agree is unconstitutional, but I think that without the language that gives LCAR the unconstitutional veto power, what we really need is more specificity in here about what the rulemaking should look like, because without that, it's just essentially, there's not much guidance provided here for the rulemaking. So I think that there should be more statements of legislative intent associated with the rulemaking provisions, but I agree with Governor's Counsel that the provisions about LCAR should be removed.
Thank you.
And I think that's all my comments.
Okay. Any questions from Mark? Pretty clear? Thank you. Michelle, can we get a list of the crimes currently expungible and the ones that are just built? That would be, sealable?
Does smell like that.
You mean
It smells like somebody
Yeah.
sneaking a
Aside
cigarette.
from
Smoking.
what the law is, you mean
What
like-
current law
Amy.
allows to have
a
a
cigarette
cigarette
out there.
Maybe outside.
versus what current, what this proposal
Never a good
to be
smell
out
when any of those are.
Yeah, we're a government.
Where did they say this came from again?
I don't know.
I assume Ledge Counsel.
No, because I gave her a copy. Ben gave her a copy of it.
Yeah.
Ben and May.
You know, I don't know that it
Hey,
could
Ben?
be like
Where did this come from
everything,
again?
but it's all, you know,
From who?
And leaders.
Oh, okay, okay.
Also, some through this email, so the language on the rules, Michael agreed, and so if you guys want to discuss around that policy on the rulemaking, I would suggest.
Yeah, it's a good thing we're gonna be here till next June, because other than that, we can't get this bill out of here. This bill is more complex than anything I expected to come. I thought that they were just gonna, I didn't expect them to do these things. So to try to change the, the unconstitutional sections they added to try to do some of these things. Unless we're here till June, I can't do it. I don't think this committee can do that. But I also don't wanna change what we currently have as expungible and not allow it to be at least sealable. If it's in the current law that you can expunge it, if they subtract these crimes. Do you have a list of that?
I can put one together by, the end of the day.
Well, that'd be good if you could work with Michelle on a list of what currently is expungible and what would be sealable under this law. And I agree, there's a lot of grave robbing going on.
Actually, I'm not sure I can do it by the end of the day. I just-
Well, can you do it by next
I can do it by,
Monday or Tuesday?
yes, I can definitely get it done.
Okay. So Tim Lauder's 2 months, we've got about 20 minutes.
What people can do later is speed me up or slow me down if I talk too quickly on YouTube. That's what I often end up doing. So I think Tim Leaders Dumont, Department of State's Attorneys and Sheriffs, I posted some materials on your website, including Evan Meenan's 50 state survey. Just wanted to quickly start with that. From our perspective, 41 out of the 54 jurisdictions we looked at, when they're using the word expunge, it's not what Vermont would use in terms of expungement. Only 17 of the 54 jurisdictions appeared to have something resembling automatic expungement, and 0 jurisdictions made all convictions eligible. And a number of those jurisdictions allowed access to prosecutors, for the criminal justice purposes that you're discussing here today. And that's on your website, just so you have that from our perspective. And a little context, I asked the judiciary, I think last month, maybe just over a month ago, over the past 4 years, there had been 47,000 expungement orders pending right now in our criminal justice system, including the juvenile cases. There's about 25,000 pending cases. So it's a lot. And every single one of those, there's maybe 5, it sounds like there's some dedicated staff in the judiciary. We do not have dedicated staff to address expungement orders. And when you have 1 count of 3 counts, for example, expunged, you physically have to get out a black marker and expunge that. And for example, if an individual was acquitted or found not guilty at trial, and that defendant wanted to later access that record, and it was expunged because it did not result in a conviction, we would have to tell that defendant accused of something as serious as murder that no such record exists. And for us, it's also, expungement from our perspective has hindered transparency, some access to defendants, opportunities to sort of tell their story about what happened. And another example is I've had cases where I dismissed a case with prejudice because the person was engaging with restorative justice process outside actually of the even normal diversion pathway. And if I were asked today what happened with that case, I would have to say no such record exists, even though the media at the time reported that the individual was arraigned. And so for the purpose of what I would say transparency, integrity, but also defendants being able to tell what happened to them in the future, we think going to the sealing track is an important path forward. I agree that we should expand whatever the list of crimes are that are sealable. We've been saying that for some time now. I think that would be fine by us. Happy to work with anybody on what that looks like. And overall, I think there was this 11th hour change to create super sealing. But overall, the bill is something that we've been supportive of. We think that 10 years may run into some issues, that 10-year super sealing where then we can no longer access things. There are cases, including a case out of New York recently where the 9-year-old girl was located because of a 20-year-old sealed record where they were able to locate the person's address. And so even benign records can sometimes help us solve serious crimes and find justice. I did speak with a number of state's attorneys over the past few months on this issue, and independently, I didn't do the group chat, independently spoke with them, and some reoccurring themes came up about why moving to sealing would be an important pathway. And I agree with you, happy to talk about whether deferreds, et cetera, should be dropped out, and I think we're happy to keep talking about that. But one of the issues that we've run into is, let's say the following: the state dismisses a case because the principal witness provided false information. That intel is then destroyed. That witness is a witness in a future case. Without the destroyed intel, neither the state, defense, nor jury will know that the witness maybe shouldn't be trusted. And without that knowledge, the defendant in the future case could be prosecuted more severely, or in fact erroneously, because we have to respond, no such record exists if a expungement order applies to the entire case file, not just the fact that they were subject to the allegation, but the affidavit, the materials there within. And so we hope that the conversation can continue on this, I think, important opportunity to move to a simpler system. And it's not just about, I mean, I'm sitting here saying this, we full-heartedly think that individuals who have served their time, been convicted, should have the opportunity to work in the future, to have gainful employment. We have dealt with enormous administrative burdens with respect to complying with expungement order processes. And that, I'm not going to harp that. You've been hearing that for years. So I'm not going to harp on that. But I do think there's a pathway here where, from our perspective, expungement has, and we know this because I've received public records requests from defendants. I want my case file. Give me my case file back. And I have to say to them, no such record exists, even though I know that's not the case. And that feels wrong. As a government employee, that feels wrong for me to tell that defendant that I can't give you the case file where the case was dismissed, you were acquitted, et cetera. And as the public records officer for the department, I receive calls pretty much every single day from administrative professionals and state's attorneys. How do I comply with my constitutional duty to disclose Brady and Giglio material to defendants while also respecting, which is federal constitutional baseline, while also respecting the fact that there's a state law that says that certain records have to, and it's that balancing act here. And so I've sort of pictured a head-on collision, the public records law and the expungement law.
Well, it's a balancing
Right,
act.
exactly.
But I think Marshall put it well. You are presumed innocent until found guilty. And, you know, that's a basic tenet that we learn in elementary school, I think. Or maybe they don't anymore, but I learned it in elementary school.
Did you go to a public school?
Yeah.
There you go.
I guess a question that I have is, if, you know, going back to the super sealing, which seems to have been a last minute addition, which I have never heard the term super seal. If the system were similar to the juvenile system where you can access a record, but you need a court order to do so. Once it's been sealed,
So
once it's been
hypothetically,
super sealed, you could get a record, but you would need a court order.
I'm just playing this out physically. So let's say the conviction happens, and then,
Well, it's a misdemeanor. 3 years have gone by.
okay,
And then
yeah,
there's
and
an
then 10,
application to
right.
seal, blah, blah, blah.
so then 13 years later, it gets
13 years
super
later,
sealed.
It gets super sealed, and then
After
in
that,
the future, you would need a court order similar to the juvenile.
I would be willing to definitely talk about that as long as during that 10-year period, we still have the access. that's
My
provided.
understanding is there's some access during that
Yes, there is,
10-year
absolutely.
period.
Yes, that's correct.
So
Criminal justice purposes. yes.
the understanding was that at some point, the information is no longer all that useful. But you've described some where it might be. So rather than completely throwing the baby out with the bathwater, if you had a system similar to the juvenile where you could get a court order to open.
So in that super sealing time period, where in the way it's currently written in the bill, the only individuals that could actually look at that record, use that record would be the defendant. So in the hypothetical, right.
My hypothetical means that you would,
Right.
you as the state's attorney of Addison County would go to.
I appreciate the promotion.
Well, I don't know if that's a promotion.
Maybe a demotion.
It could be a demotion.
That's right.
Don't let me get into that in the last 2 minutes. Rutland County,
There we go.
more populous,
Yeah, I'm happy where I am.
less challenging. Anyway, you're a state's attorney, you wanna get to the record, you go to the judge with the reasons why you need to get that.
Yeah, in that super sealing window, I think that's something we could talk about. Certainly, what I was gonna say, just so I was out there and very blunt with you all, because it's April, is we did not support the inclusion of super sealing. It wasn't testified to, et cetera. And so if there was going to be super sealing, we'd want a longer window. And thinking about that 20-year-old conviction from New York, you know, that's something where we've seen it being.
Well, at some point, though, most cases are over, you know.
Except for if a PCR comes back and there's no statute of limitations for PCRs.
Understood. But I'm just offering this as
Yeah. I think we'd be willing to talk about that, whatever that looks like, that process in the super sealing time period.
I mean, you must have done it sometime for a juvenile.
Yeah.
Have you? I mean,
I personally have not.
somebody must have. As a state's attorney, you did it.
I would defer to the former state attorney from Rutland.
I'm happy to respond. I mean, Rose Kennedy, for the record, I think that makes a lot of sense. I mean, we were playing hypotheticals in our office last night about legitimate reasons why beyond that 10-year period, we may want that record. And, you know, putting some sort of safeguard language in this that allows for those legitimate purposes makes sense. So I think what you're describing, Senator, makes sense.
Thank you.
And
Have you ever used that?
I don't know if I can think of a specific case right now, but I'm sure I have.
And one thing I just wanted to add is an alibi contained in a destroyed affidavit or one we can no longer access. It cuts both ways. It's not just about prosecution. It's about defendants being able to say, hey, actually, I was accused of something else I didn't do.
I'm just
right?
offering a suggestion of compromise in a position which.
I think we'd be happy to talk about that, definitely.
Well, why don't you think it over?
Okay.
Senator Norris.
Yes, thank you. It seems the more we talk about this bill, the more confused I get. And sometimes that doesn't take much, I guess, depending on who you talk to. But so is it my understanding, and we've heard a lot of testimony here when it comes to DNA, fingerprints, and so on and so forth. At the end of this so-called super sealing, will anybody have access whatsoever to those records?
As this bill is drafted, the defendant, that's it.
Researchers.
Right,
So
and
what about-
and researchers as well.
So what about those individuals, let's just say, who have maybe been improperly incarcerated or cold cases that may arise or whatever else?
If the state came into contact with a record, we would have to respond that it does not exist.
So that's it. There's no more, get somebody else who's improperly
Well, that's-
incarcerated, there's no more.
Bob, that's why I was suggesting they would do the same thing they do in a juvenile case, where the case has been sealed. They can go to court and get the record.
As long as there's an avenue to,
Well, that would be,
Right.
there is no avenue in the bill right now.
as it exists.
The avenue would be, after 10 years, would be similar to.
Like an elevated process after 10 years. Yeah.
Okay, thank you.
Senator,
So now I'm confused. In an instance where someone is incarcerated wrongfully, their record wouldn't have been expunged. They were incarcerated for that. They're actively incarcerated for that crime, correct?
If the case was dismissed with prejudice or it was later, if it were expunged for whatever reason, because you can post, I mean, in that hypothetical, if they were actually convicted, and it wasn't dismissed or otherwise subject to expungement, then yes. In a hypothetical where someone was convicted, but then after the fact it was dismissed, et cetera, and then it could be expunged. For example, in PCRs, we can negotiate and stipulate things to alter what had happened years prior. If that makes sense, it would sort of depend. But if someone was actually convicted and incarcerated, it would depend on the circumstance. Wrongfully is sort of an interesting word because it would have to trigger whether would be subject to expungement or not.
Well, right, and my understanding of the question is if it was determined while they were incarcerated, they were wrongfully confused and that convicted.
Confused and convicted.
Confused
Yeah.
and convicted, that if that record had been expunged, it wouldn't be able to be used to exonerate them.
That's
I
correct.
can't imagine a circumstance in which someone is incarcerated for a crime they've been convicted and their
If
record
it
would
was
be
expunged, we would have
Right,
to,
but this bill would not allow for that to be expunged if they were still in prison for that crime.
if the record were expunged under current law, regardless of what happened, we would have to respond that it didn't happen.
No, I
Oh,
understand that. What I am saying is this bill and our current law does not allow for someone who is still serving for the crime they were convicted of to have their record expunged. So there would be no instance in which they were still in prison wanting to use their record to exonerate themselves, in which
I
it
would
would have
want
been expunged.
to diagram exactly what you're
That's on
saying.
the exoneration.
Yeah,
We're
yeah.
talking about sealing overs.
I believe we have the laws set on the exoneration. It's a different section of law, but we did that 10, 12 years ago. And that, my recollection of that law is it depends on the state's attorney just dismissing the record, which then under this bill would get expunged, as I understand it.
Yeah, but if you're right, if someone was.
But you can be exonerated and still have the record on the books, because in the case of the guy from Massachusetts, he sued Massachusetts, not because he was upset with the police or anybody else. It was the prosecutor who refused to apologize. And so he sued the Middlesex State's attorney who hadn't dismissed the case. So it's all case specific on the exoneration. I don't know about the Manhattan Five and how those individual cases were dealt with.
Right, and they're always gonna be in the media, unfortunately, too, which is something that is entirely a part of the world that we live in.
One of the most compelling testimony I ever heard was got this former sergeant from Fort Devers in Massachusetts who got accused of rape in Middlesex County, Massachusetts. And 18 years later, he always refused and was not allowed to be released because in Massachusetts, if you don't admit to your sex crime, you can be held under civil commitment. So he was there for 18 years in jail. And then they found panties in a box in the bottom of the courthouse. And the DNA exonerated her.
But I think we're supportive of going towards a sealing regime as repeated by the Attorney General's office and the Governor's office and Department of Public Safety, and happy to see where this goes, if we can be of any assistance on finding a
Well, I
pathway.
think it can be of assistance by helping us understand what it is that you're trying to get at after the so-called super seal occurred.
I would say complying with our other duties to defendants,
Well,
et
look at
cetera.
how the juvenile system works, and if that works. That period, that's something we can consider. Obviously, I'm proposing it, the rest of the committee hasn't weighed in yet.
Well, thank you for your time, and hopefully I was quick enough. I tried to speak quick.
Well, you're perfect, just quarter up.
Excellent.
So we're gonna adjourn, and just a reminder that